Hey everyone, and welcome back to The Explainer. Today we're jumping right into the incredibly fascinating world of statutory interpretation. It really helps to think of the law not just as a dry set of rules, but as a vast and, let's be honest, sometimes really complex map that we all need to navigate. But here's the good news. When lawmakers draft a statute, they don't just leave us wandering around out there in the wilderness. They leave us clues. So today we're going to be decoding two of the absolute most misunderstood clues on that legal map: headings and marginal notes.
Okay, let's kick things off with this brilliant analogy straight from our source notes. It says, if the long title is the name of the destination and the preamble the reason for the journey, headings and marginal notes are the signposts along the road. I mean, how perfect is that? It just completely captures what these legal tools actually do. They aren't the final destination themselves, but they are absolutely crucial for keeping us on the right path when the legal text gets a little murky.
So here is our roadmap for today. 1. Signposts on the legal road. 2. Headings, which are helpful, limited guides. 3. The plain meaning rule. 4. Marginal notes, essentially unreliable summaries. 5. The constitutional exception. And finally, 6. Your core exam signpost. Let's dive into Section 1, Signposts on the Legal Road, Navigating Legislative Intent.
Now, what's really interesting here is the actual origin story of these signposts. Headings and marginal notes share a common and honestly somewhat surprising origin. They are very often inserted by draftsmen or officers of the House, rather than being subject to full legislative debate by Parliament. Think about that for a second. Because they aren't always directly argued over and voted on by lawmakers, we have to proceed with a massive note of caution when we use them to interpret the law.
Moving on to Section 2, Headings, Helpful Limited Guides. So what exactly is a heading? Well, legally speaking, headings are titles prefixed to individual sections, we call those cross-headings, or groups of sections, like your chapter headings. Our notes point us to classic cases like Toronto Corp from 1907 and Martins v. Fowler, and those cases establish that a heading is to be regarded as giving the key to the interpretation of the clauses under it. They basically act as mini preambles to the provisions that follow them, jumping in to help clear up any doubts. Which brings us right to the golden rule for headings. Yes, they act as preambles, and yes, they are absolutely legitimate aids to resolve ambiguity in the sections following them. But, and honestly, this is a massive but, they absolutely cannot control or restrict plain unambiguous language. As it was established in CITV Ahmed by Umarbai, the title of a chapter cannot legitimately be used to restrict the plain terms of the enactment. Basically, if the text is perfectly clear, the heading has to take a backseat. All right, Section 3, the plain meaning rule, when text defeats the title. This whole concept begs a really high-stakes question. Can a simple heading actually restrict how a law is applied, like even to the point of deciding whether someone goes to jail or walks free? Well, to answer that, we need to look at a tale of two very different cases. First up, let's look at the famous case of Director of Public Prosecutions v. Schildkamp. This one involved Section 332(3) of the Companies Act 1948, which dealt with fraudulent trading. The main issue here was whether a person could be prosecuted for fraudulent trading while the company was still an ongoing concern, or only when winding up had actually been initiated. Now, a literal reading of the text, just by itself, didn't limit the rule to companies that were winding up. It looked like a totally general provision. But Lord Reed noted the physical layout. The section was located within a fascicule, which is essentially just a legal term for a group or bundle of sections, and that specific fascicule dealt exclusively with the liquidation and winding up of companies. Lord Reed made a brilliant observation here. He noted that since many provisions aren't discussed in parliamentary debate, the physical layout of the printed act is a vital indicator of Parliament's intent. Because there was real ambiguity regarding the scope of the text, the House of Lords used the part, subpart, and cross-headings to determine its true meaning. Ultimately, they held that prosecution was not tenable while the company was an ongoing concern. So in this case, the heading successfully restricted the application of the law solely to winding up companies. But now we have to contrast that with the 2013 Supreme Court case, Union of India v. National Federation of Blind. In this one, Section 33 of the relevant act was titled Reservation of Posts. The actual text provided that the government shall appoint such percentage of vacancies not less than 3% for persons with disabilities. It was argued that the reservation should be based on the number of posts specifically because of that heading, rather than the total vacancies. But the Supreme Court stepped right in and said absolutely not. The clear, unambiguous wording of the text explicitly laid out the computation is against total vacancies, completely defeating the heading. And putting these side by side brilliantly illustrates the exact boundary line for headings. In Schultkamp, we see that when the text scope is genuinely ambiguous, the heading can step in and restrict the meaning. But in the National Federation of Blind case, it proves that when the text is crystal clear, like explicitly stating 3% of vacancies, a heading saying reservation of posts has absolutely zero power to change those unambiguous words. Plain meaning wins out every single time.
Which brings us to Section 4, Marginal Notes, Unreliable Summaries.
So what is a marginal note anyway? According to our source material, they are simply summaries printed in the margin of the act to catch the eye. Think of them as the somewhat unreliable sidekicks of statutory interpretation. They exist purely for quick visual reference, definitely not for deep legal analysis. Because they are just quick visual summaries, a really powerful legal consensus has formed around them. Basically, they carry little to no weight in modern interpretation. Back in the 1962 case, Chandler v. DPP, Lord Reed held that marginal notes cannot be used as an aid to construct the meaning of a statute. And you might be wondering, does this differ depending on where you are? Not really. In Balraj Kunwar Jagatpal, it was established there is no reason for giving marginal notes in an Indian statute any greater authority than those in an English Act of Parliament. And this was firmly reaffirmed by Justice Patanjali and CITV Ahmed Bai Umar Bai, stating they absolutely cannot be employed to restrict the meaning of clear language in the bare act.
Now let's look at Section 5, the constitutional exception.
Okay, get ready for a plot twist. While marginal notes in standard statutes are generally ignored, marginal notes in the Constitution are considered part of the text itself. The rules just completely flip here. We can actually see this dramatic exception perfectly illustrated in our source notes through two really major landmark cases, the Golagnath case, which looked at Article 368, and the Bengal immunity case of 1955 regarding Article 286. So the crucial point is understanding why and how these constitutional notes work so differently. It all comes down to the fact that they were actually debated and adopted by the Constituent Assembly. Because of that, they are held to be part of the Constitution itself. Therefore, courts can actively use them to construe the scope of articles. For instance, in the Golagnath case, the marginal note to Article 368 was explicitly referred to in order to understand the immense scope of Parliament's amending power. It provided vital prima facie clarity that simply wouldn't be allowed if this were just a standard everyday statute.
Finally, Section 6, your core exam signpost.
I want you to basically lock this comparison into your memory because this is your ultimate core exam signpost. On one hand, you have headings. They act as preambles, they have persuasive and interpretive value to provide context, and they are totally legitimate aids to resolve ambiguity. Though remember, they can never ever override plain text. On the other hand, you have marginal notes. These are essentially just summary labels with minimal to no legal force, meant purely to catch the eye. Unless you are dealing with constitutional law, where they suddenly become part of the actual text itself. Keep this mental Venn diagram in your head, and you are going to navigate these interpretation questions flawlessly. As we wrap up, I want to leave you with this really provocative thought. If unelected draftsmen are very often the ones inserting these standard signposts without full parliamentary debate, how much hidden power do they truly hold over the plain text of the laws we live by every single day? It's a totally fascinating tension between the physical layout of a document and actual legislation. And it's exactly why understanding the nuances of statutory interpretation is so vital. Thanks so much for joining me for this explainer. Keep analyzing, keep questioning, and I'll see you on the next deep dive.